Hey, well, grab your beverages and make your way back or sit down, and we have a real fun one coming up. Medically assisted dying, euthanasia, suicide. Oh yeah, this is my CBC headline, so I'm trying to get your attention. Big splashy, maybe it's Fox News. Okay, so what we have is a very interesting debate coming up. Debate isn't really, I guess, what it is. We're discussing it. And we're hoping that there's going to be a lot of questions at the end. And this is a very pertinent issue because this has gone to the Supreme Court. Now, when was it at the Supreme Court? When was it heard?
October 15th.
November?
October
15th. And any inkling of when a decision will come down?
Probably before May.
I would think so. Probably about 6 months or so.
Now you see me deferring to these two. They were both involved in the litigation. So this is going to be very interesting. We have Grace Pastine. She's from the BCCLA, BC Civil Liberties Association, and André Schutten, who lives in Ottawa and is with the ARPA, the Association of Reformed Political Action. I'm going to get it right one of these times. I actually follow them on Facebook, along with the BCCLA. So anyway, we're going to let Grace start. Then Andre will come and give his bit, and we're going to make this as specific as they're comfortable and you're comfortable talking about the Carter case. So store up your questions. We want to have a lot of questions at the end. Everyone will do their best to respond. And seeing as, I know I don't have to warn this audience in any sort of way, but this is obviously a very emotional and hotly contested moral issue. So when you're asking questions, you can ask tough questions, but make sure you're respectful. And again, I know this audience, I don't have to say that, but we'll let our friends talk now. So Grace.
So I'd like to begin by talking about my client, Gloria Taylor. Gloria Taylor was a vibrant and independent woman. She had a zest for life. She had a variety of careers and occupations over her life. When I knew her, she was a mobile park home manager. She was a grandmother. She'd been a motorcycle enthusiast for about 25 years. At age 61, she was diagnosed with ALS, which is also known as Lou Gehrig's disease. And her doctor told her that the disease would likely quickly paralyze her. Over the time I knew Gloria, she lost the ability to open a jar, the ability to walk, the ability to lower herself onto the toilet, the ability to pull up the sheets when she was getting cold in bed. ALS is a devastating disease, as I'm sure many of you are aware. It affects the ability to control the muscles used for breathing, is one of its can be one of the most major results of ALS. And because of that, Gloria started to use a respiratory ventilator. But she was absolutely terrified that eventually she would struggle for breath, be unable to breathe, and die, as she put it, gasping like a fish out of water. Gloria was a woman of faith, and she also believed that God didn't want her to suffer. And she believed that the government shouldn't be able to tell her how to die. She wanted to die on her own terms. She wanted to have a say in how she would say goodbye and how she would be remembered. If her suffering became unbearable, Gloria wanted to have the choice of a peaceful, a dignified, and a pain-free death. She wanted what many of us want, which is she wanted to die at home. She wanted to be surrounded by her friends and family that loved her, and she wanted to pass away easily. She didn't think that was too much to ask for, and the BC Civil Liberties Association didn't think so either. But the criminal laws prohibit an assisted death, and that's why we decided to file this lawsuit. As Derek mentioned, this case was heard by the Supreme Court of Canada last October. And what we argued is that the federal laws that criminalize doctors for helping competent, seriously ill individuals who are suffering unbearably at the end of life are unconstitutional. And they're unconstitutional because they deny individuals the right to have control over decisions that are fundamental to their lives and that prevent unnecessary suffering. I think many people on all sides of the spectrum of debate would agree that this case really reignited a public debate that had lay dormant for a number of years. I'm not going to discuss the law in any detail here today. You can read about the law. You can read the 400-page decision of Madam Justice Lynn Smith of the BC Supreme Court. Madam Justice Smith struck down the laws that criminalize physician-assisted dying, and she granted Gloria a constitutional exemption that made Gloria the first person in Canadian history to win the right to seek the assistance of a doctor to have an assisted death. But I'm not going to talk about the law because actually I think the outcome of this case will depend more on the facts and the policy issues than on the law. And so that's what I'll speak about today. In the view of the BC Civil Liberties Association, there are really three compelling reasons why the Supreme Court of Canada should decriminalize physician-assisted dying. And those three reasons are the values are based on the values of compassion, or mercy, based on wanting to provide safety for Canadians, and third, based on the principle of choice or autonomy. So I'll speak now about why we believe decriminalizing physician-assisted dying would provide sick and dying Canadians compassion at the end of life. In our view, no one should be forced to suffer a violent, prolonged, violent death. Seriously ill Canadians deserve the peace of mind and the improved quality of life that comes with knowing that if their suffering becomes intolerable, a peaceful and a dignified death will be an available option to them. In our case, we provided the evidence of individuals who were seriously and incurably ill and wanted the right to choose a gentle death. And these were men and women with the types of diseases that we know and fear: MLS, terminal cancer, Huntington's disease, locked-in syndrome. These men and women provided compelling narratives to the court of suffering and the fear of suffering that they faced, as well as their desire to make decisions about their own bodies based on their own values and beliefs. At trial, the Crown referred to these real stories by real people as our quote, blood and excrement evidence, and sought to have it excluded. The court, Madam Justice Smith, admitted the evidence and determined that the impact of the legislation on real people was relevant to determining whether or not the legislation at issue violated rights and freedoms and could be justified under Section 1. So these individuals told the court how the law forces them to make incredibly difficult decisions when they're already suffering from diseases. Take their own life while they're still physically able to do so, and that's because it's not a crime to take one's own life. Suicide was decriminalized in 1972. But for many individuals, they feel as though they still have months or perhaps years left in which they could enjoy a good quality of life. Or they risk living past the point where suicide is no longer an option and they become trapped in an unbearable dying process. Many of the individuals who provided evidence in our case died in the very circumstances that they tried to avoid by joining the lawsuit. And they were denied the safe, peaceful, and legal deaths that they so dearly wished for themselves and their families. Peter Fenker and Ian Petrie, like Gloria Taylor, both had ALS, and they died agonizing deaths from their diseases. At the very end of his life, Peter begged his wife of, I believe, 35 years to take a gun and shoot him, or if she couldn't do that, find a rope. Ian was also suffered from, as I mentioned, ALS, and was filled with terror as he choked and suffocated at the end of life on his own secretions, which is quite common for someone suffering from ALS. Both men, at the end of these long marches to death, were sedated to the point of semi-consciousness, so they wouldn't have to suffer anymore. But their struggle continued over days while their families kept vigil at their side. And I think of, if you are suffering yourself or watching a loved one suffer, perhaps 3 days doesn't sound like a long time. But for those people, it's an eternity. And living with those memories of having a loved one die in that way is very traumatic. Ian's wife, Marilyn, said to me, you know, Ian suffered so much with this terrible disease. What was the point of making him suffer even more at the end of life? Two other men who provided evidence in our case died in circumstances that they would not have wished. They took matters into their own hands. One man died of over-medication from medication he was able to procure on his own and committed suicide while his wife waited in the adjoining room in their home because he was afraid that she would be criminally prosecuted if she was even by his side. Another man, Tony Nicholson, he had locked-in syndrome. He was only able to communicate through a computer program and blinking his eyes. He decided to take his own life after his appeals were exhausted in a case that he started in the UK. When he lost, he starved himself to death, refusing food and water until he passed away. I'll turn now. I think I've given some examples of the harm and the hardship that the law causes seriously ill individuals. I'll turn now to the principle that we think is also engaged, and that is the principle of safety and protecting Canadians. In our view, the regulation of aid in dying, not the criminalization of doctors, provides the best protection for Canadians. A physician-assisted death would only be an available option in the rarest of circumstances for individuals who meet rigorous criteria. In this respect, some of the most valuable evidence that was before the court was the evidence of years of meticulous study and research as to the working operations of regimes around the world that have legalized or decriminalized physician-assisted dying. A significant number of countries now allow for physician-assisted dying. In the United States, just a couple of examples, the states of Oregon and Washington, Montana, New Mexico allow for physician-assisted dying. Belgium, Luxembourg, the Netherlands, there are other countries around the world as well. Many of these jurisdictions have legislated or judicially developed safeguards that protect the vulnerable, yet provide for choice at the end of life. And these safeguards can cover a whole variety of issues, including the type of assistance that's permitted, the conditions that would qualify an individual for assistance. So, for example, does an individual need to be defined as having a terminal condition? Does suffering need to be a precondition for being able to receive an assisted death? They speak to the way in which a request must be made. Does it need to be a written and an oral request? How many oral requests? How many written requests? The age of the patient, requirements for consultations and referrals. How many doctors does a patient need to see before assistance will be permitted? And then finally, some of these regimes outline types of reporting or scrutiny for physician-assisted dying. Several jurisdictions allow for aid in dying where there's no legislation specifically directed to the practice of assisted dying. For example, in the state of Montana, aid in dying is governed by the professional standards of the medical profession and the criminal law. Much of the government's argument at trial was directed to the concern that permitting aid in dying would set in motion a slippery slope, and that would lead us to permit assisted dying in non-voluntary contexts. The argument is that even if there are safeguards for protecting vulnerable people, the infallibility and or the malevolence of doctors or those administering the practice would render any safeguards inadequate. And these are obviously concerns that need to be taken very seriously. The most important evidence in our case, again, was the vast body of empirical evidence that's been collected in permissive jurisdictions. And that's from physicians actually working in permissive jurisdictions, researchers who have extensively studied those systems. And what this body of evidence demonstrated was that the safeguards are effective in protecting fundamental human rights. The record that was before the courts in this case was voluminous. There's really no comparison between the record in our case and the record before the courts in Sue Rodriguez's case. One claim that's raised repeatedly is that abuse occurs with some frequency in the Netherlands. And again, any potential for abuse needs to be taken very seriously. The evidence from, time doesn't allow to get into too detailed of a discussion of the Netherlands, but what I will say is this, is that it's frequently misconstrued. Some of the deaths that opponents claim are evidence of deaths that were non-voluntary or evidence of abuse are actually instances of palliative or terminal sedation, two practices which are both legal in Canada and in the Netherlands and are considered ethical. One other point, final point I'll make on the Netherlands is that what's interesting is that deaths in the Netherlands that were not the result of an explicit request actually decreased after legalization of aid in dying. And what the evidence shows is that rates of these deaths is generally greater in countries that do not allow for legalized aid in dying than those that criminalize it. Of course, in our case, we advocate for physician-assisted dying only where there is an explicit, informed, voluntary request for an assisted death made on the part of an individual who is mentally competent and able to make that request. Madam Justice Smith of the BC Supreme Court determined, based on the totality of the evidence that was before her on the various ways in which these regimes work across the world, that risks can be identified, they can be minimized, and a carefully designed system can uphold fundamental human rights and protect the vulnerable. One of the key findings of evidence from permissive jurisdictions was that there is no disproportionate impact on socially vulnerable populations. So for example, in Oregon, the individuals who tend to seek an assisted death are overwhelmingly white, they're well educated, they're middle or upper class. In fact, it's the privileged, not the weak and the vulnerable, that tend to seek an assisted death. Now, the government argued that it's simply not possible to design a system with safeguards that would be rigorous enough, that there would always be the possibility for some sort of error, and that even if there was the possibility of one wrongful death, that would be one too many. In our view, to accept this approach would effectively immunize the law from any type of constitutional scrutiny. No claimant would ever succeed in a challenge to the law under the Charter. Sorry, I missed that. Madam Justice Smith of the BC Supreme Court agreed, and she rejected this approach. And what she determined was that the zero tolerance approach was actually incompatible with the Charter exercise, which requires a court to balance the salutary and the deleterious effects of a law. The deleterious effects of the law are well documented. The law perpetrates great harm and suffering on people across Canada. People like Ian, people like Tony, people like Peter, Nagy, and Gloria. Their suffering was horrific and it was certain. And that has to be balanced against the speculative concerns that the government raised. And I think just importantly, it should be noted that prohibition does not lead to the elimination of lives lost through assisted dying. Rather, it means that what exists now will continue to exist. And that's a hazy maze of back alleys that put vulnerable people at even greater risk than a legalized scheme would. Individuals resort to violent suicides. Like Tony, they refuse food and water to bring about death. They order medications from Thailand or Mexico. They develop kind of macabre killing machines. You may have heard of helium and turkey bags. Some of these attempts will result in death. Others will lead to brain death, organ failure, even worse. Our view is that we need to take these practices out of the darkness and expose them to the light. Now, the final issue I'll address is choice. And this third reason for decriminalization is based on choice and the principle of autonomy. We believe that we're deeply personal choices regarding end-of-life care are involved. Those choices should be made by the individuals whose lives are at stake. There is extensive evidence before the court about end-of-life care in Canada, particularly palliative care. In Canada, patients have the right to accept or refuse medical treatment. For example, a patient can refuse kidney dialysis or to be placed on a mechanical ventilator, even if that choice will lead to death. Physicians may legally administer medications, even though they know that the doses may in some circumstances hasten death, so long as the intention is to provide palliative care to ease a patient's pain. So palliative sedation is ethical and it's legal. The government argued that there was an ethical bright line between these well-accepted end-of-life practices and physician-assisted dying, that there was a bright line between acts of omission and acts of commission. That is, between killing and letting die. In Rodriguez, the Supreme Court of Canada accepted that distinction. We don't. We called the opinion evidence of philosophers and ethicists, and what we argued is that there's no principled or ethical distinction between these practices. Withdrawing treatment, pain management, and palliative sedation can all be justified when they're the outcome of a patient's informed choice who's decisionally capable of making that choice, and they serve the best interests of the patient in preventing unnecessary suffering. Finally, one of the most important principles in medicine is respect for each patient's autonomy and the right to choose. In our view, it's simply not the role of government to say that some medical choices lead to a natural death, a so-called natural death, while others do not. In conclusion, I'll just say that this is very much a case about real people with serious illnesses who, through a change to the law, can find some peace and comfort in knowing that they have choice at the end of life. I think in the last 20 years, there has been a sea change in social thinking on these issues. There have been repeated calls from all quarters of society, whether it's academics or ordinary Canadians or those more prominent such as Dr. Donald Lowe, for this issue to be addressed at the national level. A recent poll that I believe came out in August of last year indicated that 86% of Canadians favor a change to the law for individuals who are seriously and incurably ill and suffering at the end of life. In June 2014, Quebec became the first province to adopt physician-assisted dying legislation. And just recently, in August of last year, the Canadian Medical Association adopted a resolution at its annual meeting supporting the right of all physicians, within the bounds of the law to follow their conscience when deciding whether to provide physician-assisted dying to a seriously and incurably ill patient. Our lawsuit will have far-reaching implications. The court will determine whether the provinces are constitutionally entitled to enact legislation such as Quebec has done, and whether the federal laws that criminalize physician-assisted dying are unconstitutional. In our view, Canadians who are suffering have the right to a dignified death, and we are very much of the view that now is the time to give suffering Canadians the compassion and the dignity that they deserve. Thanks.
Perhaps before I get started, could everyone just stand up for me for a second? Stand up. And feel free to sit right back down again. I just want to get the blood flowing a little bit because we're sitting right after lunch, and I know what that does to people. So, and while you're seating yourself, I just wanted to thank the BCCLA for a couple of other issues, for their defense of Trinity Western University, as well as your defense for pro-life clubs like at the University of Victoria, for example. Thank you very much for your very principled stand for freedom in this country. And that's what I really like about the CCF and the organizations that you work with, is that we can sometimes vigorously disagree on issues and still have a really good dialogue about this matter. And I suspect many of you are going to disagree with my position on euthanasia, and that's okay. You're allowed to be wrong once in a while. But nevertheless, I feel welcome to speak here and share my position. I'm going to start with just a few minutes talking about my position, especially as it relates to palliative care. Then I'm going to give 3 reflections on the Carter hearing, one on the slippery slope, one on the discrimination claim that was made at court, and then another one on the right to life versus the autonomous choice conflict, and which one should trump the other. And then if I have time, I might give a prediction on how the court's going to rule and what I plan to do after that ruling comes out. So thanks again to Grace for beginning with these stories about individuals who are involved in this debate, Gloria Taylor in particular. Sometimes people from my side of the debate forget that this is about real people suffering real pain, and we like to argue about it in the theoretical, and we forget that it's about real people, so thank you for reminding us all about that. And I think the answer to the very pressing problem of end-of-life care, and particularly how a painful or traumatic life ought to end, how and when that happens, is a difficult, very emotional, and also a moral question. And my position is that to die with dignity does not require the legalization of euthanasia or physician-assisted suicide or physician-assisted death, but rather through the promotion of better quality palliative care. Now, palliative care, for those of you who don't know, is that field of health that specializes in pain management, especially, though not exclusively, at the end of life. It's typically holistic, should be anyway, meaning that it's not just pharmaceutical, but it's also emotional, spiritual, communal assistance to ease the transition out of this life. To use a perhaps too simplistic line, palliative care seeks to kill the pain, euthanasia seeks to kill the patient. Now, this is a very pressing issue, all the more because of our rapidly aging demographic. End-of-life care will be a massive expenditure for all provinces in the next 30 to 50 years. But it doesn't have to be this way. It doesn't have to be so expensive. As I said, part of palliative care is speaking to the emotional and spiritual needs of the patient, something that the state is not all that well prepared or suited for. So palliative care strategy could, or it should, include in-home care, incorporating care through family, through church communities, and so on. This lowers the financial burden on the state, while at the same time addressing what most people at end of life desire most, and that is companionship, relationship, meaningful interaction on an emotional, personal, and spiritual level. And interestingly, most people at end of life are not afraid of the pain or the suffering. They're most afraid of being alone or being perceived as a burden on their loved ones. So we have to address those concerns as well as the concerns about pain and suffering. I need to also clarify that I have no problem with the removal or refusal of exceptional medical care. I do not believe in preserving life at all costs. So there's a fundamental, in my opinion, there's a fundamental ethical, moral, and legal difference between euthanasia and assisted suicide on one hand, and the refusal of medical treatment on the other. If someone wants to shut off their ventilator, if someone wants to refuse chemo treatments or requests a do not resuscitate order, that's morally and legally acceptable. I have no problem with that, and I think it's very distinct from physician-assisted death. It's kind of my introduction. So the three reflections on the Carter case. The first one about the slippery slope, and I know everyone here who disagrees with my position is thinking slippery slope is a fallacy, which is true, but there's also the slippery slope logical argument. Look it up, it exists. And that says that if you can prove that this leads to this and you can show all the steps, then it's a form of logical argument. I'm probably not going to be able to convince you that it will do this, but I'm just going to point to the hearing itself and give you 3 quotations from 3 different lawyers, all arguing for assisted suicide, and I'm going to show you that the slippery slope was in effect right there in the courtroom. So Joseph Arve, counsel for BCCLA, Gloria Taylor, and so on, he said this: to be permitted to have euthanasia assisted suicide, there's six criteria you need. You have to be an adult, has to be competent, has to be voluntary, has to be fully informed, has to have a medical condition that is irremediable, and the suffering has to be intolerable to that person. Okay, 6 conditions. He said again, quote, assisted dying should only be allowed in the most serious cases. So to you, I'm going to ask you or challenge you to always, when you hear that, ask the question, why? On what foundation can we impose any limits once we cross this Rubicon of allowing some people to kill other people legally? When you hear someone say only in these very limited situations or circumstances, then ask the question, why those situations? Because one of the next lawyers that got up to argue, he focused on personal autonomy. This is counsel for the Canadian Civil Liberties Association. He said, quote, we would start from the proposition that you do not have to be physically disabled nor terminally ill as long as you are competent. So one of those 6 criteria just got knocked off the list. And he's still, I think, within the same logical framework as the BCCLA. And then a little while later, the Counsel for the Farewell Foundation for the Right to Die got up, and he argued, quoting here, the limits of eligibility criteria such as disability, suffering, intolerable suffering, terminal illness, and so on, are incompatible with autonomy. So he suggested that we can't have physicians even administering the lethal dose because that too interfered with personal autonomy. So we've knocked down the physician requirement and also anything that might limit or be incompatible with autonomy. Later on, Arve said also this, quote, if a subsequent case comes around that says as a matter of constitutional law, the law should be extended to not just adults, so contemplating children, or not just those who are competent, so perhaps someone who's got Alzheimer's or something like that, well then he says that's the charter working, that's not the slippery slope, we call that the living tree in this country, end quote. My argument is that is the slippery slope. In the courtroom itself, on October 15th, we saw the slippery slope manifest, which is natural, because once we say it's okay for some people to kill other people, we have no objective basis to limit that right. That's my first observation. Second observation is on this right to autonomy versus the right to life. The CCLA also argued preservation of life does not trump personal autonomy. In effect, we actually see the opposite argued, that the right to autonomy must trump the right to life. I think the BCCLA was very clever, very smart in their strategy. They said that due to Bedford, right, the prostitution case, all we have to prove is that these laws undermine the right to life, liberty, or security of the person interest. That is, in their interpretation, the autonomous choice of just one person. And then the onus shifts to the state to justify that law under Section 1. Now keep in mind, no violation in the history of the Charter of Section 7 has ever been justified under Section 1. So if BCCLA wins under Section 7, history tells us they'll probably win under Section 1 because the government's never won under Section 1. Yet, so the standard for BCCLA is to only prove just one person in all of Canada happens to be affected or their rights are undermined by this law is immediately suspect. Yet, if we look to the trial judge, she said that none of the systems introduced or considered are perfect. Paragraph 883, she says, I conclude that the risks inherent in permitting physician-assisted death can be identified and, key phrase here, very substantially minimized through a carefully designed system imposing stringent limits that are scrupulously monitored and enforced. Very substantially minimized. She didn't say eliminated. She said minimized. So the trial judge and counsel in this case admit implicitly that innocent people will die. For them, it's simply a matter of balance. So do you see what's happening here? We have two different standards. One is this violation of the autonomy rights of just one person. That's totally unacceptable to the appellants. And yet a violation, or a risk, I should say, of innocent people dying, well, that's an acceptable risk in this balancing of rights. To me, that doesn't sit well. Third observation, this discrimination claim. I'm going to give my perspective from a criminal defense perspective. I know there's a couple of criminal lawyers in the audience, so I only did criminal defense for half a year, so correct me if I'm way off base here. But did I get a glass of water? Anyway, Justice Abella, when the argument for discrimination under Section 15 was brought up, my respectful submission is that Justice Abella got it ass backwards when she kept hammering the Attorney General of Canada on the decriminalization of suicide. The purpose of the decriminalization of suicide in the 1970s was to help people not to commit suicide. It did not create a benefit in law for people to commit suicide. And yet, Justice Abella, I think, was quite stuck on this point, suggesting that people with a disability, unable to kill themselves, they're discriminated against by the state. She said the equal benefit of the law, in my opinion, the equal benefit of the law is not having equal access to death. That's not the benefit of the law. If there is an equality interest in this case at all, and I don't think there is, but if there is one, then that equality interest is in the equal benefit of the law interest to have equal access to fulsome protection of your life by the state. Okay, so it's going to get a bit tricky here, but I think if there's one role for the state, I don't care, thank you very much, I don't care how libertarian you are, you're not anarchists. So if you believe that there's a role for the state, it's to protect the lives of its citizens from other people. So let me show you how this is undermined. Who is the prosecutor's main witness in a criminal trial of someone charged with interpersonal crime? Rule of thumb, prosecutor's main witness is the victim. So who's the prosecutor's main witness in a homicide trial? It's the victim. But what's the problem? The witness is rather unresponsive when called to the stand. Okay, so stay with me here. When the criminal law is changed such that some people are allowed to kill other people, it now becomes a burden on the state to prove that, in fact, the person killed, beyond a reasonable doubt, a very high standard in law, that that person consented or did not consent to be killed. And common sense and the nature of this entire euthanasia debate, I think, dictates that those who are disabled are much more likely to be assumed to have wanted to die, creating this reasonable doubt, whereas a strong and healthy person won't be at risk of suffering that assumption. So what does this mean in effect? In effect, this means that disabled Canadians, as a class of people, Section 15 equality rights, disabled people are provided less protection and benefit of the law vis-a-vis the homicide provisions in the criminal code, less protection than able-bodied people, when that absolute ban on killing is removed. In a homicide trial, okay, that's going to be a trial by jury, do you think a jury of 12 people will find someone guilty of homicide for killing a severely disabled person if we say that that it is legal to do so as long as that person consented to do so? You think of Robert Latimer. Okay, euthanasia was illegal when he was charged, and a jury still found him not guilty for the murder of killing his daughter Tracy. It had to go back to trial, I think, at least once, maybe twice. So, in my opinion, it appears that Justice Abella, Counsel Joseph Arvey and the BCCLA say that's an acceptable risk, and for me, I say that's not an acceptable risk. So those are my three observations of the hearing. Do I have time to speculate on the outcome of the case? Okay. I think bad form to predict what the Supreme Court's going to say, but I'm going to do it anyway. I've tried to predict it 3 other times and I got it way wrong all 3 times. So hopefully I'm wrong on this one too, but my guess is that the court will rule probably 7-2 to strike down the law, and that they'll give Parliament 12 months to draft a new law. That's my guess. So we have 2 options. I have 2 options to advocate for. The first one I'll talk about for 10 seconds, and then I'll talk about the second option for a little bit longer than that. The first option is the notwithstanding clause. Yeah, that's not going to happen. Next option. The next option is to set up as restrictive a regime as possible, similar to the standard that we have for a constitutional exemption. So, in my opinion, I think for it to work, for us to eliminate as many possibilities of breach of, for innocent people to be killed, I think we have to first of all make sure that the determination is not just a medical one, it has to be a legal one as well. Okay, so we need doctors and a judge involved. So I would propose 2 doctors, independent from each other, must make a determination that this person does indeed meet the criteria, and that a judge also makes the same determination. Secondly, it has to be limited to those very, very exceptional cases. And third, I would argue that the procedure must be documented by video from start to finish, starting with the request for death, the hearing, the meetings with the doctors, the hearing with the judge, the lethal injection itself, and the medical declaration of death. The entire thing must be video recorded and must be accessible to the general public on request. The reason for that is so that we have as much information as possible to ensure that, in fact, we are not killing innocent people. Of course, I'd prefer that we just keep the law the way it is. Those are my submissions, if you will. Derek, welcome any questions.
So I am a physician, and I oppose striking down the law. And we did a survey of specialists in Quebec. Our federation did, and 75% of doctors in Quebec were for the law, but only 20% said they would actually do it. And I suspect that the number would be much less when it actually came to actually doing it. Per se, because it's not a good thing for your patients to think you may kill them at some point. So I think that we have to think very clearly about what we're doing, because we're actually giving doctors the power to kill people, and I don't like that idea. And my palliative care colleagues firmly oppose this. Almost everyone firmly opposes this. And I think that in a situation where we have limited resources, people are going to be told that it's cheaper for you to die. And it will be pressure done in the most gentle of ways, but it will be there. So that's why I oppose this. And I've written as such in the National Post a few weeks ago.
Do you want to comment?
Sure. Well, thank you for your comment. The BC Civil Liberties Association is aware that there is not uniform support amongst doctors for legalizing physician-assisted dying. But in fact, that actually should give Canadians great comfort. We want doctors to be involved because doctors are reluctant gatekeepers, and they will only want to provide assistance in dying in the rarest of circumstances for patients who are suffering unbearably at the end of life and are capable of making a free and informed choice about hastening their death. That being said, I think that we have noticed a real change in the last 10 years or so amongst doctors. The vote at the CMA annual meeting that I mentioned is just one indication of how doctors' attitudes towards assisted dying have changed. And we certainly take the position that this is only something that assistance in dying should only be provided by those doctors who are willing to do it. Doctors must be able to make this decision within the bounds of their practice and their own personal conscience.
Yeah, the numbers are interesting. I think Grace cited a stat, something along 83% support for euthanasia generally in the population?
86.
86. And I've read a stat that said 80% of doctors oppose it. So it says something where the medical community itself is on the different side, almost completely opposite of what the general public is at. Yeah, I know that at the Supreme Court, a couple of interveners made arguments for the freedom of conscience of physicians for them not have to do it. Although I think the new policy coming out in Ontario is already hinting that doctors would have to give positive referrals if they did not want to do it, which is also a conscientious problem under Section 2A. So I'm not sure how much comfort that is for physicians who find that it's not medical care.
Just a follow-up to the question about the physician's position. I wonder if you can speak, either of you, to the principle or expectation of doctors to do no harm and how that interplays.
Yeah, the Hippocratic Oath once said, still says, I guess, it hasn't been changed, that do no harm is the line that they swear to, doctors swear to, and that includes that they're not going to, I would assume, it would include the promise to not kill your patients. Obviously, it depends on what your perspective on physician-assisted suicide is. I suspect that Grace is going to say that there's more harm in not assisting your patient to commit suicide, and I would say that no, the greater harm is in killing your patient. I think that the better approach is to tackle the pain itself. The dignity argument lies in, or I think human dignity lies not in the autonomous choices of the individual. I think autonomy is related to dignity, it informs dignity, but it's not the ultimate measure of dignity. The ultimate measure of dignity is the fact that we're human, we're people. The dignity is inherent in us, not in the choices we make. And so the doctor, I think, has to respect the human person first, not necessarily the choices that particular patient is advocating for in that particular moment, especially when it violates the human person. So do no harm, in my opinion, would include refusing to kill a patient and instead focusing all efforts on palliative care, eliminating the pain as much as is possible.
André hinted at what my response would be to that question, and many of the doctors that provided evidence in our case told the court that when they were faced with patients who were suffering unbearably from incurable diseases at the end of life, they wanted to be able to provide, or they thought it was that their patients deserved to have a choice, to have an assisted death, and that was very much in line with their duty to their patients to provide care at the end of life. I guess I would also just kind of reiterate that many of the concerns that have been raised about providing assistance in the context of a physician-assisted death apply with equal force in the context of currently accepted end-of-life practices, such as palliative and terminal sedation, withdrawing or withholding life-sustaining treatment. And yet there's no federal legislation directed at these practices. Rather, they're governed by the professional standards of the medical profession and various provincial laws of general application. And there's really no argument made that these practices are too dangerous or unethical or unprincipled. But you can clearly see how, let's say, an individual who wants to have their mechanical ventilator removed, they could possibly be coerced by a family member into making that decision. Perhaps they're not mentally competent to make that decision. I mean, there are real risks in those circumstances as well. And yet what the medical profession has done is respond to those risks in a robust in a robust way. The doctrine of informed consent is what guides those practices, and if a doctor has concerns that a patient is not able to provide informed consent, then they can be referred to someone else for a competency assessment, and that assessment can be made with a high degree of accuracy. So what we're really saying is that if those practices are ethical and moral, and we say there's really no principled distinction between physician-assisted dying. And so I'll just make one other point, if I may, which is doctors in our case also presented evidence to the court that the laws as they currently stand prevent them from having open, frank discussions with their patients. And if they were able to have those discussions, they would quite likely be able to put to rest some of the fears that their patients have. Patients may want to ask, how bad is it going to get? And what do I do if it gets really bad? What if I just can't take it? And yet those are the very questions that patients are scared to ask and that doctors are scared to hear because it raises the entire specter of criminal liability. Whereas if a doctor could say, this is what it might look like, and this is the palliative care that we can offer you. Here's what's likely, here's what's less likely, here's how we can address it, and there could be that open and supportive conversation between patients and their physicians, that would be a much better situation for doctors and for patients.
I have a story and then a question. The story is, I would suspect, given the youth of most people here, how many people have done a bedside vigil with a friend or family member dying in the last over a 3 or 4 day period? How many of you have been bedside? Yeah, I figured not very many. I would fall into that category as well until the last 7 months. One of my best friends, Keith Alexander, he's had cancer for 7 or 8 years, been fighting it successfully, but slowly downhill. 6 months ago, into a steep decline. Last 3 months in the hospital, last 2 weeks in palliative care. He died in late November. Why did he want to stay alive? One reason was because his wife, the love of his life, was in assisted living and then palliative care herself for the last 3 or 4 years, and he was scared to death that he would die before she would. And he didn't want to leave her. And the remarkable ending of this story was when she went into palliative care about 3 months ago, he went, before November, he went in the last week. They put them together in the same room for the last week. And I was there on Tuesday when she died. Naturally, he died naturally the next day. He kind of said, I'm ready to go now. And in both cases, it was the kind of palliative care that you both described, where they both had lots of medication on painkillers for both of them at the same time, but it had a happy ending. We had the funeral. They both went together, the same funeral, a week later. So all I'm saying is, I happen to believe, I think the policy status quo works pretty well, and it makes me very nervous to think that the whole profession of doctors who take the oath to defend life, suddenly some of them will be exempted from that. My question, though, is this. Given the importance of the debate, the widespread quality of the debate, the widespread character of the debate, the quality of the debate, which we've seen from both, why should the Supreme Court decide this rather than an elected government?
I would ask the same question.
If you get the right answer, we'll hire you.
Oh, the Parliament has dealt with this, as I think many of you know, repeatedly, almost, I think every time with a private member's bill, but it's come from the Senate and from the House of Commons multiple times since Rodriguez, every time being knocked down by very wide margins. So I think Parliament has had the opportunity to deal with it and every time said, we're not changing the law. I know Mr. Arve argued in court, he said, well, those were all private members' bills and those don't count anyway. But the fact that no governing party has also refused to introduce the law doesn't mean they haven't dealt with it. They've considered it and said, no, we're not introducing a law. So you can't point to the negative action, like the non-action of a governing party to introduce euthanasia legislation as if and point to that as evidence of them not dealing with it. They have dealt with it. It's been debated in the House multiple times, and they've decided not to introduce a new law to legalize euthanasia. I think the court should take notice of that and consider that very carefully when they make their decision.
Another thing that our lawyer, Joe Arve, said in court, and I think it's very apt, is that he said that the topic of assisted dying is a political hot potato that no party wants to touch. And I think that's absolutely correct. The fact that year after year, poll after poll, Canadians have overwhelmingly stated that they support a change to the law is remarkable, and yet there has been political inaction or political action through inaction. and we say that this really indicates a type of political dysfunction. And it's for that reason that we brought our case to the court. Yeah.
I looked at a case from New Zealand on this issue a number of years ago, and the New Zealand courts are actually pushing back against their own statute, which mirrors ours in a lot of ways, as I remember. I was rifling through my phone trying to find the case, but I couldn't. But what happened was a gentleman who decided that his terminal illness was too much to bear. I'm sorry, I got the roles reversed. His wife asked him if she could set up basically a suicide machine. And so what ended up happening is he put a number of gas canisters in the house. I think he was a welder, and he filled the house with argon or something. And so when she just found it was too much, she turned the argon on. He left the house for 2 weeks, came back, found his wife, and went to trial, was convicted, but then no sentence was applied at sentencing. So that was a New Zealand decision, I think, from maybe about 3 years ago now. So it's interesting seeing the courts. The courts are, in some cases in the Commonwealth, changing what their legislatures have done. So, okay, so I guess it's time for a break, and we'll meet again in a few minutes, and mingle, get a drink, stretch your legs, and come back excited.